Hi everyone, this is Steve Maggi from SMA Law Firm, and I'm going to talk to you today about the national interest exception as it applies to L1A applicants. So as many of you know, on June 22nd, there was a presidential proclamation that was issued that barred the issuance of visas under L, H, and J visa categories until the end of the year. This had a very profound effect on thousands of companies who had already submitted and got approvals on L1 petitions by USCIS when the embassies and consulates were closed and many people were not able to get their interviews. When this proclamation was passed, it essentially was saying that there would be no more issuance of these kinds of visas. As of August 12th, the good news is that L1A applicants for visas are now eligible to apply for their visas if they qualify under what's called the national interest exception. So I'm going to just walk you through a few of the scenarios that might warrant trying. The important thing to keep in mind here is that if you get denied for a request for an exception, that does not mean that you will not be eligible for a visa in the future. So it's worthwhile, if you have an approved petition by USCIS, to make an attempt to get a national interest exception so that your employee that you're trying to transfer or you're trying to bring back to the US does not need to wait until next year. Who can apply for this exception with success? Well, L1A applies principally to senior level executives or managers. And the argument that's needed here is that they are critical to the success of the business because of a critical infrastructure need. And those infrastructure sectors, which are particularly highlighted and enumerated in the exception, are chemical, communications, dams or public works, defense, industrial, emergency services, energy, financial services, food and agriculture, government facilities, healthcare and public health, information technology, nuclear reactors, transportation, and water systems. So as you can see, almost every category of business that uses L1A visas could qualify under this. And then the question is, what are you trying to do if you are seeking to establish a new office? It's going to be very difficult to make these arguments. But if you're not, if the company's already set up and things are functioning, you need to be able to show that this person will be a senior level executive or manager and not lower level, and that person has spent multiple years with the company overseas, including having substantial knowledge and expertise within the organization that can only be replicated by a new employee within the company following extensive training that would cause the employer financial hardship, or that they will fill a critical business need for a company meeting a critical infrastructure need. So the good news is that a lot of the criteria for the exception overlap or replicate the requirements for actual qualification of the L1A visa. And so this applies not for new office L1s, but for any other extensions or for companies in the US who are already operating and have existed for more than 1 year. If you have any questions, this is obviously a very complicated process, but very worthwhile. We suggest that you talk to a US immigration attorney with consular experience, and we're happy to answer any of your questions. Thanks for watching.